you have to understand the FBI workforce, typically the youngest FBI agent is going to be 25, 26 years old because they don't bring you right in out of college. You have to have some work experience. But if your FBI agents, their applications, you're recruiting on college campuses to get people to apply later on when they're eligible, 25, 26 years old, they have, with 25 years of experience, they have retirement eligibility at 50 with immediate payment of benefits. They don't have to wait until they're 65. They get immediate payment of benefits, sort of. And one of the reasons for that is you sort of want law enforcement people who have to run and carry guns and chase people down to some degree to not be 65. You want them to begin to cycle out in their 50s. And so you create eligibility for retirement at age 50 with 25 years of service time. So you've got essentially a 25-year life cycle in your workforce. And then they all, like coming up this year, we're going to be 25 years post 9/11. I expect that within the next 2 or 3 years, there won't be any more FBI agents who were hired before 9/11. They'll all be hired after 9/11. We don't have any FBI agents in the FBI anymore who were hired in the 90s. They're all gone.
Hey, Colemanators, welcome to the program today. We're going to go on something less than a 3-hour tour with my favorite skipper, Shipwrecked crew, who, the last time we had him on the program, hardly anyone knew his name, and I think that was mostly on purpose. He wasn't really officially, I think, anonymous, but he was pretty close. But now look at that huge 177,000 followers. He is such the man, and he's got this great Substack, so he's raking it in. Bill, how you doing?
Both of those are I'm just fooling around. They pay me to do this. This is astounding.
Bill, people, if you don't know, Bill spent many years as a government lawyer. In fact, as a federal prosecutor. And the funny thing about social media is that it's the world's largest collection of experts on the process of federal prosecution. And so sometimes Bill gets to and chooses, sometimes he even chooses to wade into discussions about how this really works. And it's really amazing just how often people pretend to know how it works and they don't, wouldn't you say, Bill?
Yeah, it's highly entertaining to me, the number of disputes I get in with people trying to tell me that I'm wrong about something I've done pretty much every day for 35 years. The thing about federal criminal trial work that is not fully appreciated is it's the same case after case after case after case. The subject matter of the cases varies across federal statutes. The procedure is the same in every case. And that's an interesting part of federal criminal trial work, is that the people who've done it know the language. You know immediately in court if they actually know what they're doing or if they're just sort of pretending, because it has rules of its own. It has language of its own that's completely different from civil work. I've done a little bit of civil work. I know enough about it to be, dangerous to myself and my clients. But it is not.
Considering some of the judges that we have been exposed to together,
yeah,
you don't have to be dangerous. The judges can add that all themselves.
They can do all the damage that is necessary in a particular case. So it's entertaining to me to go on X or other social media and listen. I'm writing something today about the Comey case and all of the prognosticators and the punditocracy on both sides, right and left, and always a source of amusement, the law professors who want to tell everybody about how trials work when trials don't happen on social media or in classrooms or in law review articles.
Or in appellate court chambers, which most of them spent a year or two clerking in. That's not the same. That does not teach you. It's just reading the cases. It's just more reading cases. And I listen. I wish I would have had the opportunity to be a judicial clerk. I didn't really try very hard, but I mean, the legal professoriate have they in our lifetimes ever been less relevant to what happens in the real world than they are now?
Well, yeah, of course, they're so it's such a one-sided debate when you're dealing with academia, whether it's the undergraduate or graduate level, and particularly in law schools. There's no intellectual debate among them. They all believe the same thing. But your first point, which is always comical to me, is this idea that being a law clerk, even in the Supreme Court, somehow makes you a superstar lawyer. I'm always shocked in the fact that so much work in judges' chambers gets done by glorified law students. It's like that law clerk, is a first-year associate who partners when money's on the line, park in a back room, scanning documents. But in the legal practice in the judiciary, a district judge, the worst possible job in the judiciary, in my view, a district judge might have 3, more likely 2 law students doing research and writing. It's just a baffling, hire lawyers, hire a lawyer who's got 10 years experience in a courtroom to do the same function as a law clerk. Now, I know judges that have. There was a judge in California who I practiced with before. He had a law clerk that had been with him 25 years.
Right. They have some judges have professional law clerks. A previous guest of ours, Jim Nault, incredible guy who was a U.S. Navy submarine commander. All the time when you were being a federal prosecutor, he was making it possible for you guys like you and I to breathe free air in the courts of the United States. Then, in middle age, after he retired, went to Cornell Law School, got a degree, became a patent litigator, and spent many years as a professional law clerk for an appellate judge. You're right. I mean, why not have someone? But you know what it is? It's a prestige thing. But it's a prestige thing for the judges who
have their law clerks advance. Right. Yeah. Now, I had an experience, and just take me a second. There was a particular judge. I thought he was a very good judge. He's a great example of the fact that he'd have been a business lawyer, never set foot in a courtroom before he was nominated to be a federal judge. But he was great. He just
sometimes they are. Yeah, sometimes they really are.
He learned the procedural aspects of it through trial and error, but he was just a smart guy that got stuff. He brought with him out of his law firm a 4th-year associate to be his law clerk. She stayed there 25 years. You knew when you were writing motions or oppositions to motions, you were writing to her because she's going to be the one that, read through everything and then discussed it with the judge and then wrote the opinion. Because why wouldn't he? He's got the person who's been through thousands of motions on his behalf over time. And again, this goes into the question of you have recurring issues in federal cases, in criminal practice, where the case law is well established, but the lawyers file them to make a record. A defense lawyer has to make a record. Even if he knows he's going to lose the motion, you still have to file the motion to preserve the issue for appeal.
Well, you just did a perfect segue for me because I actually wanted to bring it back to your original thesis, which was that there are certain things about federal criminal practice that a lot of people don't appreciate. You had a really good tweet. I'm going to still call them. I guess we're like the old people who call record players Victrola, who call stereos record players and record players Victrolas. You had a really good post yesterday on the topic of why you don't get that all these people being charged with crimes and then walking away in federal practice, as you see in state practice. And you talked about how the grand jury system at the federal level changes everything about the likelihood of getting away with literally murder.
Well, right, because the foundation of the process, because the foundation of the system begins with a grand jury indictment, and the grand jury thereafter plays no role in the case. The parties are dealing with the grand jury's indictment, which, as on its own, stands for the proposition that this defendant must plead guilty or stand trial. The grand jury has determined there's probable cause, and therefore the defendant is brought into the court jurisdiction of the court to plead guilty or stand trial. There's not any off-ramps between that and the trial, and as you get close to trial, as I said in the tweet, and I've been on both sides of this. I mean, I've been the prosecutor as well as the defense lawyer. The impending trial date galvanizes a defendant's thinking as to what should I do. There are not the same kind of mechanisms for delay or dismissal when the charging decision belongs just to the prosecutor and the prosecutor's decision making can be called into question. Prosecutor doesn't bring the indictment. Now, we all know functionally the role of the prosecutor is to present the evidence. And the prosecutor writes the indictment for the grand jury. They're not in there pounding on a laptop themselves, but that's just to ensure that it is legally sufficient. And you have the prosecutor sign the indictment, or the U.S. attorney sign the indictment, essentially as a pledge that the Department of Justice will pursue the case. That's why you don't let grand juries just sign them by themselves. Because if a grand jury was authorized to just sign it themselves, the Department of Justice say, we don't think that's a foundationally predicated case. We're not going to waste time and resources pursuing it. But
you're saying even if a given assistant U.S. attorney would take something to a grand jury, in theory, you could imagine someone above him after indictment saying, this doesn't cut it.
In theory, that might be possible, but it doesn't happen in practice because the process is the prosecutor writes a pros memo, which basically says, I've been investigating this case. I've been working with the FBI. I've been working with DEA, whoever. Here's the facts as we understand them to be based on our investigation. Based on those facts, it's my belief that the following charges can be supported by proof beyond a reasonable doubt, and my proposed indictment is attached. The supervisor, who might not know anything about what you're doing, depending on the size of the office, you've got maybe, the typical process is this gets assigned, 6 months ago. And then the supervisor, he knows what your case list is, but he doesn't necessarily know where you are at any given point in time on every case. And then at some point, as the prosecutor, largely working, either in a team or on their own. I mean, I only handled 2 cases with other prosecutors. I went through the Department of Justice in a day where every prosecutor did the cases themselves, not in 4- and 5-man teams, which is what you commonly see now. And so you would prepare the pros memo, prepare the draft indictment, send it to the supervisor to review. They might make changes. They might suggest you add charges. They might strike charges. But eventually the process was they would sign off on the pros memo. So it's just explaining to my boss why I think we should go forward.
You said the idea of having the prosecutor sign the indictment that's a pledge to whom exactly?
To the court, basically.
To the court that they're going to pursue it. But how does it even get to a grand jury if they're not going to pursue it? Based on what you're telling me.
Well, no, but that's my point is grand juries could conceivably operate on their own.
Oh.
Yeah, a grand jury is not an arm of the Department of Justice. A grand jury is actually organized and convened by the judge. I have in the past called it actually a functionary of the judicial branch. And I'm not sure that's as a technical legal matter completely accurate. But the grand jurors are impaneled by the presiding judge in the district, not the Department of Justice. The grand jury is essentially just a tool handed to the Department of Justice to use. A grand jury subpoena is just a court subpoena.
In other words, right, when when you get called for jury duty, or you can get called for grand jury duty also, that comes
Exactly.
from the sheriff. That comes from the judiciary, not from the Department of Justice.
Exactly. And a grand jury subpoena for documents is just a court order. Instead of delivering the documents to the courthouse in advance of trial, you deliver it to the grand jury for the grand jury's use.
So, speaking of something you just mentioned and indictments, let's talk about that Comey indictment. Everyone seems to have an opinion on it, even people who are, there are a lot of people on our side. The best they can come up with on it is, well, it seems kind of frivolous, but at least we're playing brass knuckle lawfare the way the other side does. Is that really, do you think, the best spin of this?
As I have said in spaces, and I have said multiple times in postings on X, I don't know, and neither does anybody else.
Stop right there.
Because
Stop right there. Most important thing for everyone to realize, and people who follow me on X know I say it all the time, to use old-fashioned terminology that hardly makes any sense anymore. If you don't have the red welt, you have no idea why decisions have been made. And there's an entire industry out there of people who make videos second guessing other lawyers or lawyers' decisions in certain cases, and we all do it because sometimes
sure.
stuff is really obviously stupid, but you never really know until you have the whole file, and we're never going to have the whole file.
Well, let me tell you where this comes from, in my view. This comes from the more recent, I should say, modern practice, if I wanted to condemn myself to antiquity, the modern practice of using speaking indictments. These indictments that are 20, 30, 40, 50 pages long that tell the story of the crime. Okay? So when you get an indictment like the Comey indictment, which is 3 pages long and tracks the statutory language of the offense, it's like, well, they must not have anything more. It's not in the indictment. Okay, well, as a federal prosecutor for 21 years, I oftentimes wrote an indictment that was 3 pages long that took 4 weeks to try. The indictment is not a reflection of the government's case. It's not an encapsulation of the evidence. An indictment, I'm writing about this now. I've got an article coming out later today, maybe first thing tomorrow morning, on the Comey indictment. An indictment serves 2 purposes. It gives the defendant notice of the charge that's been filed and enough factual information so that they can prepare. Where did it happen? What date did it happen? And what am I accused of doing?
People confused charging documents with civil complaints.
Exactly.
And they don't understand that civil complaints are not evidentiary documents either.
Right.
They're just giving notice to the other side of what their problem is.
Exactly. And that's why it's called a notice pleading and not, it's not, it has a limited function. It is not evidence. And in fact, juries are told the indictment is not evidence. It's simply an allegation. And indictments play no role in the trial. Nobody gets on the witness stand and reads the indictment.
Well, that did happen, actually, didn't it? And it got thrown out. So in the last few months, which case was it where the judge let them read the Chicago 7th Circuit. The judge let the prosecutor read the indictment into the record after the cooperating witness went flippy floppy on him.
Oh.
And the 7th Circuit said, we have never heard of anything that insane.
Well, let's take it back to one of the J6 cases that I had, was involved in, one of the Oath Keeper cases. It became a real issue in that trial, and I pushed to have the indictment go to the trial jury, which I knew that was pushing on the boundaries, but I was a defense lawyer because I wanted.
What's the tactic there?
I wanted the jury to see how different the evidence was than what the government claimed it was going to be in the indictment. And the judge said, Mr. Shipley, I understand what you want to accomplish, But why is what the grand jury said in the indictment relevant to the trial evidence in the case? The jury in the case is told they should only consider the trial evidence, the witnesses they heard and the documents that have been introduced, and nothing else. You're telling me to give them information that's outside the trial evidence. And my response was, yeah, but it's so good for me. Which, it's a tactic, but that underscores why indictments are meaningless after they're returned. They are not an encapsulation of the evidence. They're not a reflection of the evidence. They do two things. The first one I explained, which is they give the defendant notice. And the second thing it does is it allows the defendant the opportunity to plead double jeopardy if it applies. The defendant could say, Your Honor, I've already been tried on this charge. In a prior case, it dealt with the same offense on the same date and the same location, and I was acquitted. You can't do that unless the indictment is specific as to, so enough specifics have to be in so that the defendant knows that he can or cannot plead double jeopardy, because double jeopardy is an immunity in effect. It's like you're not obligated to go through a second trial. But beyond that, there's no obligation to put any evidence in the indictment.
So let's talk about the specifics of this indictment, though. Here's a guy who really undermined the justice system. He was part of this Get Trump operation. He leaked information, all kinds of real big boy bad acts, and we're reduced to threatening the president on social media. No matter what else comes out of trial, I mean, here I don't really think the question is there going to be enough proof? Yeah, a few people, I think it was you asked a hypo, right? What if there's an incredible smoking gun text?
Correct.
Where he says, okay, maybe, who knows, that'll be interesting. But at the end of the day, it's a threatening the president charge.
Right.
Is all the other stuff kaput? Was that the best we're going to get with Comey?
No, he's not. There's no preclusion of filing. I presume. Again, we don't know. There's no evidence of what there or no information about what the actual evidence being gathered is. But we have this grand conspiracy, for lack of a better description, investigation taking place in the Southern District of Florida that Joe DeGenova was just put in charge of. That there has been reports of Brennan being in the crosshairs and grand jury subpoenas haven't gone out, and that so you would assume, Comey and Brennan worked hand in hand for a year, basically from June or July 2016 until Comey was fired in May of 2017. They're working hand in hand in the whole Russia hoax investigation. So he clearly, I would presume, if that investigation is bona fide and is proceeding, then Comey's caught up in that. This became an opportunistic indictment. He brought himself into the crosshair, so to speak, by posting the picture.
Is it possible? What's the premise for jurisdiction over Comey in South Florida? Does he live there?
No, but the Mar-a-Lago search I wrote an article on this. I wrote an article on this months ago. The allegation is going to be that there was a continuing conspiracy that began in the summer of 2016 to deny Donald Trump his rights to be elected. By operation of by using the levers of government. So you have
under color of law.
Yeah, you have violation of civil rights under color of law. And his civil right was to stand for election to public office, and they used the government's operative levers to interfere or obstruct that. And if that's a conspiracy, and then the argument is the conspiracy continues after he's elected, and then it continues to keep him from being reelected in 2020, and it continued to keep him from being reelected or being elected again in 2024. You can have a shifting cast of characters. You can have people coming in and out of the conspiracy if you can show a through line from the beginning to the end. And the search of Mar-a-Lago, whatever the justification was, in August of 2022, and just Trump's residence in South Florida, gives you venue in South Florida for the entire conspiracy. Because you can have venue over a conspiracy in any district where any act in furtherance of the conspiracy took place.
And why? Why would a federal prosecutor appointed by a Republican prefer to bring charges in any district in the galaxy other than the District of DC?
Well, and that's going to be a big problem. I have come around to the view that we really need to seriously look at dissolving the district court in DC and the circuit court in DC and making them part of either Maryland or Virginia.
There's no constitutional or other reason that they should exist, and it's terrible policy.
It's a company town. I mean, not only do like 30% of the residents work for the federal government, another 40% work for a company whose business is tied to the federal government.
And why should a city have its own circuit? Can you imagine the circuit of New Haven? I mean, just there's a reason that we operate. I mean, look, I have a whole topic. I've written my article also on reforming
it can't be because there's so much litigation connected to the federal government. It's like, well, hey, the Ninth Circuit's pretty damn big too. If you want to make them part of the Third Circuit, where's Maryland? Maryland's the Fourth Circuit. So if you want to make them part of the Fourth Circuit, Maryland, Virginia, make them part of the Fourth Circuit and just add judges to the Fourth Circuit, just like the Ninth Circuit.
Now, that Mar-a-Lago raid, was that before or after you finally had your come to Jesus moment about what was the difference between the professionalism in your day and what was going on over the last 10 years or so?
Oh, long after. I was already doing J6 cases. That was August of 2022, and I had started doing J6 cases in October of 2021. So
people, just for listeners who are not familiar, Bill was a punching bag for many years because he would try to calmly explain how just as we're doing here, how federal prosecutions work, how the FBI works, how the Justice Department works, and everyone out there saw it working differently. And Bill is explaining, no, it's not really, until the point came when it was obvious that all the expectations, all the understanding of how the world worked, not only on Bill's part, but for so many of us, could no longer be squared with reality.
Well, Andy McCarthy and I came to the same conclusion about the same time. And Andy McCarthy and I have communicated via email and other ways for years and years and years.
He slips back.
He's a little more of an institutionalist than I am, and he's antagonistic towards the Trump administration. I understand all his reasons for being so. I don't fault him for that. And we are, he's a friend. We just disagree on some things. But he had the same kind of, no, the FBI would never do that attitude in 2016 as I did. I was still saying, no, look, I worked with the FBI for 20 years. There's too many safeguards that would ever allow that to happen. But I had seen over my last few years in Department of Justice, the FBI's approach to things began to shift, and the mindset of the younger agents began to reflect a social justice approach rather than a criminal justice approach. And that became pervasive over time. I mean, that came to dominate the Bureau for reasons I can explain, and Department of Justice, both. And it's purely a function of recruiting and where you look for new bodies. So Andy and I both had this mentality based upon 25 years of our own experiences that said, no, that never happens. There's too many safeguards in place. It could never happen. And then to realize, but it was the people at the very top who could set all those safeguards aside. That's exactly what they did. And they did things that we could never conceive of. And the first indication I had, well, it was the Nunez memo, which kind of laid out, Devin
Devin.
Nunes,
Yeah.
my former congressman. I should remember his name. Devin Nunes working with Kash Patel and the House Select Committee for Intelligence gets access to some of the records behind the Carter Page FISA, which was part of the investigation of the Trump campaign and later the Trump administration in 2016, 2017. And I remember exactly what triggered me is Devin Nunes said, the FBI said I could send one member of the committee into a SCIF, a secured facility, to read the FISA affidavit. And Devin Nunes said, I'm not a lawyer. I wouldn't know what I'm reading. So there's no point in me going in there to doing it. He said, I sent Trey Gowdy. Trey Gowdy was a former AUSA in South Carolina. I figured he would know what he was reading. And then I saw an interview with Trey Gowdy on Fox or wherever. He was still in Congress at the time. And Trey Gowdy said, it's so much worse than I could have ever imagined. It's like, okay, that's meaningful. Somebody who knows what they're reading saying, you can't believe what they did. And that, for me, and I think for Andy as well, it's like, we're going to have to kind of backpedal and reconsider all the assumptions that we had always maintained based on our own experiences, and maybe those aren't operative anymore.
It's a gigantic deal. I mean, one of the things that struck me, and I wrote a lot about this, I mean, we're already almost kind of past it, is there was a commitment that was undertaken by Democrats, by grown-ups. I'm not talking about hippies. It's not 1967. By supposed adults to dispose of norms, to dispose of fundamental guardrails that everyone who was involved in government understood existed. And we see this now has bled into the judiciary. It was bad enough when it was law enforcement, and that's really bad because well before a judge gets involved, as you saw Mar-a-Lago, that can happen to anyone and does all the time. But the judges...
Let me explain to your audience and to you where in my experience it's come from. And I've written about this many times, to the extent, your viewers have read my stuff. They've seen this played out by me. For historically, right or wrong, I'm not validating or defending the practice. Right or wrong, historically, the FBI, just to pick one federal agency, I've been told it happened across the entire government, has been dominated by male college graduates, many of whom came out of the military or came out of state and local law enforcement. And then they wanted to go to the feds. And the FBI didn't have to go recruit. They had more applications from those two sources of new agents than they needed. So that was their recruiting pool. That was the pool of new agents. Until even the mid to late 90s, an FBI recruiting class at Quantico was 85% male and 15% female. Well, Barack Obama, after he was elected in 2008, and remember now you got your post-Iraq war, you got a lot of men coming out of the downsizing of the military post-Iraq. The combat brigades are getting smaller, or the active duty military is getting smaller. Combat brigades are being, whatever the word would be, and captains and lieutenant colonels are leaving the military and looking for employment. FBI is a landing ground. DEA is a landing ground. IRS, those where those guys tended to go. Barack Obama deliberately and purposely and publicly said, we need these federal agencies to be more of a mirror of society than they are. They're too white. They're too male. And the solution for that was to alter recruiting standards. They didn't hire the military. They didn't hire state and local law enforcement. They went to college campuses. When you go to college campuses, what are you going to get? In the 2009, 2010, 2011 post-Iraq timeframe, You're going to get social justice warriors. You're going to get soft social science majors and not accountants and engineers. And that became a dominant feature of FBI recruiting starting in about 2009 and 2010 and continued throughout the Obama administration. Now, you have to understand the FBI workforce, typically the youngest FBI agent is going to be 25, 26 years old because they don't bring you right in out of college. You have to have some work experience. But if your FBI agents, their applications, you're recruiting on college campuses to get people to apply later on when they're eligible, 25, 26 years old, they have, with 25 years of experience, they have retirement eligibility at 50 with immediate payment of benefits. They don't have to wait until they're 65. They get immediate payment of benefits, sort of. And one of the reasons for that is you sort of want law enforcement people who have to run and carry guns and chase people down to some degree to not be 65. You want them to begin to cycle out in their 50s. And so you create eligibility for retirement at age 50 with 25 years of service time. So you've got essentially a 25-year life cycle in your workforce. And then they all, like coming up this year, we're going to be 25 years post 9/11. I expect that within the next 2 or 3 years, there won't be any more FBI agents who were hired before 9/11. They'll all be hired after 9/11. We don't have any FBI agents in the FBI anymore who were hired in the 90s. They're all gone. They've all retired. You have mandatory retirement at 57. You can stick around past 50, especially if you don't have 25 years, you're not fully vested. But at 57, they kick you out. You hit the road, Jack. So you have this workforce that completely turns over every 25 years or so.
And keep them, and they because of that gold-plated reputation of FBI, former FBI agent from ancient times, they go into influential second careers. They go into social media content, safety regulation. They go into
Fortune 500 security. They command big dollars, and some of them come out. I mean, the license to print money retiring from the FBI is to be a polygrapher. An FBI polygrapher is like the absolute gold standard of polygraphy. It's just your phone rings nonstop. You do as many lie detector tests for corporate America as you want to do, and you charge whatever you want to charge because they're going to pay it because nobody in the world is considered better at it than you are.
Even though it's a complete scam.
Well, it has uses.
It has uses, but
So you're exactly right, though. Not only do you have this window of retirement between 50 and 57, you have a motivation to get out so you can go on to this entire second career. If you leave at 50, you can have a 25 career in corporate America that you retire at 57. And the entire time from 50 to 57, the FBI sending you a check every 2 weeks. Because you don't have to suspend your retirement payments because you take other jobs. Those checks show up. And so, you can call it double dipping. You can call it whatever you want. It's been an employment feature of the FBI forever.
Yeah, that's the deal.
So because you have this turnover now let's do the math. Barack Obama begins to feature and focus on hiring social justice warriors who are committed more to solving the injustices of the past rather than the crimes of the present. Beginning in 2009, we are 2026. We are 17 years into this. And there's only maybe the 4 years of the first Trump administration where that wasn't the hiring priority.
Maybe, right? I mean, because we saw how little effect Trump had on actually changing practices in government.
Exactly. And that was the caveat I was going to put in place. Is he didn't do a whole lot because I don't think people around him realized that needed to be done. So the FBI under Jim Comey and then later under Christopher Wray didn't change a lot from the FBI under Barack Obama and then Joe Biden. So you in effect had, closing in on 20 years of a workforce that is completely transformed from a political point of view as to what its mission is, as compared to the Elliot Ness FBI agents of days gone by, the 80s, 90s, 00s when I was there working with these guys every day. And I saw it. I saw it firsthand doing the January 6th cases, and dealing with FBI agents and prosecutors who had absolutely no resemblance to the people I worked with when I was in the Department of Justice. It is so overtly political now. It has such an overt political perspective on its mission.
That's one part of the Department of Justice. Now let's talk about the lawyers in the Department of Justice.
It's worse. It's worse.
Because they're not even in law. At least someone's inclined towards law enforcement. They might actually be, generally speaking, pro law enforcement.
Right. Well, it's worse because if you go back in the same time frame, same thing happened to the Department of Justice. And I've been told it happened across the entire federal government workforce. It wasn't just, I lived through it. I saw it happening around me. I saw it in the offices of the people up and down the hallways who began to be hired starting in 2009. Every time I post this online, I say, oh, same thing happened in the Department of Defense. Same thing happened, in all the civilian agencies. Not so much talking about the military, but in the civilian agencies. Same thing happened everywhere. The hiring priorities changed. They brought in people with different politics. As a general proposition, people are going to hire like-minded people. You wouldn't expect a supervisor who's got a history with the Lawyers Guild. That's a Lawyers Guild, right? That's the super radical leftist collection of lawyers. You wouldn't expect a supervisor with a Lawyers Guild to hire 4 Federalist Society members in a row to be subordinates.
Right.
Okay. So like-minded tends to hire like-minded. And in fact, I was just talking to somebody about this yesterday. In my first decade with the Department of Justice, 92 to 02, basically spanning the Clinton administration, I was in a relatively smaller office. There were only like 25 of us. Everybody knew everybody's politics, and nobody cared because it didn't have any influence on the work. We could argue politics all day long, but we were still in the process of chasing drug dealers and fraudsters and bank robbers. And politics didn't enter into that. But when the entire mission of the department is shifted by political leadership into a more overtly, every administration has priorities. Here's a great example. The Clinton administration, if you remember back in the day, deadbeat dads was a big thing at the federal level. We're going to go after deadbeat dads. Okay, fine. We can do it. It's not an insignificant or unimportant issue. And the Clinton administration decided it was something they wanted to emphasize, and that was fine. And then the Bush administration came in, and the other thing, Clinton administration was big on firearms. We want to prosecute people using firearms. The Bush administration, not so much. You have more Second Amendment advocates in the Bush administration. They're a little lighter on that, but they wanted to go after drug traffickers or users in possession. So there's always shifting priorities. But when an administration like the Obama administration comes in and says, you know what we're all about? We're all about climate change. It's like, you're basically telling half your workforce to leave. And then you're replacing them with like-minded. And now your entire workforce is like-minded on these social justice issues.
Do you think the reason Pam Bondi ultimately had to go, I don't know the mechanics, I don't know, jumped or pushed, was that she couldn't get through the accretion of uncooperative staff? Is that?
Oh, I think it had a lot to do with it, but not because she couldn't get through it. It's just a grinding process that takes time. While AUSAs are a little easier to get rid of than like civil service FBI, you just can't come into the FBI and say, liberals to the left, conservatives to the right, everybody to the left, you're fired. You can't do that. Now, little more leeway in the Department of Justice. One of the ways they get rid of people in the Department of Justice, which is how they got rid of me in 2013, and that happened, is they give you stuff to do you don't want to do. I was getting assigned felon in possession cases that I had done in my first year as prosecutor, and I was no longer getting assigned complicated conspiracy cases, which is what I'd been doing for 15 years. And that's just the subtle signal your time is up, which I didn't have any problem with. I'd been there 21 years. It's not a lifetime job. It's not supposed to be. And I stayed longer than I ever planned on. So, it's like, hey, I was getting a little nudge. Hey, Bill, it's your time to go. Make room for somebody else. Okay. I always knew that day would come. But then here's what happens. I get replaced by a young Asian female, 2 years out of Yale, didn't even know what door to use to get into a courtroom. So you're trading a 21-year guy with 70 trials for a second-year, don't even have to describe her, a second-year individual with a very different outlook for the job, who doesn't even know where to sit in a courtroom. She lasts less than 2 years and never tries a case, and she's off to a public interest law firm. But you do that enough times, and you change that workforce as well.
Well, I mean, Harmeet Dillon certainly changed the composition of the Civil Rights Division that way. I think she would have been actually probably happy if a few more people who weren't offended by her views, but who just maybe, that may or may not have been their way to go. But just to have the hands, I mean, she can't fill seats there.
It's terrible. But I'll say this. I mean, you obviously know Harmeet well. I don't know her as well as you do, but I know Harmeet. I don't think either one of us are surprised by the manner in which she went about taking over. That's who she is. And that's, you know what you're getting when she walks through the door. But the door she was given to walk through, which is the right one, that's where she belonged. That's where her talents were going to be most quickly revealed. That is the location in the Department of Justice that I have always said, that's the true believers. They are not going to change their beliefs to accommodate a new administration's priorities. They're simply going to hit the streets. And that's exactly what they did. They resigned in huge numbers because they weren't going to do Voting Rights Act cases anymore. They weren't going to do FACE Act abortion clinic access cases anymore. They weren't going to do the things they signed up for. That's why they were there. And Harmeet says, no, we're going to do religious liberty cases. Like, I don't even believe in God. I'm not doing religious liberty cases.
She's even treating the Second Amendment like some kind of civil right. Right. Who knew?
So that was expected. I was not surprised at all. I was actually just, that was like, for me, that was like popcorn eating time. Let's see how this plays out. And more than once, more than once, it crossed my mind, I should call her and say, I'll come back for 2 years to help you sort this place out because, you don't need to be the only person cracking heads here. But, the circumstances, have weighed against that.
Circumstances are complicated.
Yeah. So, but there are other departments. There are other parts of the department that the mission is not political, but you have the same problem where the underlings who have been there, brought in by the Prime Administration, don't want to listen. They want to do what they've always done. They don't want to change their priorities.
It's amazing to me how people are still being rooted out. People are being given explicit executive and management instructions and just deciding they're not going to do it. I mean, in general, it's a great argument for less.
That's how you get rid of them, though, because there is a formal process and the disciplinary structure, which a lot of people probably know the acronym. It's called PIP, PIP. You PIP people performance improvement plan. You bring them in. You say, look, here's the deficiencies in your performance. You've been told to do X, Y, Z, and you failed to do all three of them. You have 90 days under a PIP. You have 90 days to correct your deficiencies to our satisfaction, or you're going to be subject to termination. So it's a process. It's established in regulation and law. It can't just be ignored or set aside. And
yet there are lawyers who will sign papers suing the government for firing federal employees, going through all who have gone where management has gone through all the hoops.
Right. And they still want to object.
And they won't object. And what's the worst thing that happens is the lawsuits, like, no one gets sanctioned. A guy like John Eastman gets disbarred for whispering in the ear about a possible tactical approach in a lawsuit. These guys are signing rules papers under Rule 11 on patently frivolous political claims no one's ever sanctioned. And
the collateral problem is, while they're able to tie up their disciplinary proceeding, you've got an unhappy employee who's now even doing even less than they were doing before, but occupying a spot. And staffing in the U.S. attorney's offices and probably to the litigating divisions as well is based upon what they call SGEs. Or no, SGS different. There's an acronym for the number of slots you have. FTEs, full-time employees. A U.S. attorney's office gets a number. That's their FTE. You can have this many employees, and your budget for personnel is whatever it is. How you divide up the budget to account for your full-time employees is up to you. So you get a budget and you get a maximum number. You can't go over the maximum number. Well, now some of your maximum number are unproductive. They're sitting in offices refusing to do the work they're assigned while at the same time fighting their termination. And it's all just a combination for the kinds of consequences that were visited upon Pam Bondi because, stuff couldn't get done based on the unrealistic expectations of the public about how fast it should get done. This stuff takes time.
People really don't have it. First of all, they don't even appreciate how everything in the law takes so much longer than a normal person would think they would. Well, the judge said X. Why didn't X just happen? No. It's not like that. Judge said X. An order has to come out. The lawyer has to explain it to his client. The lawyer has to have time to review. Things don't. That Boasberg, he just turned the plane around.
Well,
he knows better than that.
Call somebody. Get him on the phone. Get the pilot on the phone. Yeah. Well, let me give you a good example. This comes out of the Comey case. A lot of the questions being raised about why did this take 10 months? Why, he posted this picture in May. Why wasn't he indicted that week? Why is he only being indicted now in April the next year? And I don't know if any of this is true. This is just a hypothetical as to what can eat up time. Okay. Let's say you figure out you subpoena his communications. So you get text messages and emails. And you can see that in the aftermath of the posting, maybe you don't get the actual, you got to get a search warrant to get the actual communications, but you can get the phone records that show he was, on the day of the posting, he contacted his book agent 4 times, he contacted his publisher 3 times, he contacted his wife 3 times, he contacted one of his adult children who's a lawyer 3 times, and it's like, okay, we need to know what all those conversations were about. So we're going to drop grand jury subpoenas on all of them. Bring them into the grand jury. Ask them about these conversations. What did you say? What did he say? Blah, blah, blah. They all get lawyers. And it's like, okay, well, how about if we just interview your client first? Let us interview him. If, there's nothing to offer, then maybe we do away with the grand jury, blah, blah, blah. Okay, that's fine. We'd like to do that. We're going to do a proper session. I'll bring my client in. But I can't do it for 4 weeks. My calendar's calling. Okay? All right, we'll set it 4 weeks. Bring the client in 4 weeks later. You sit down. You go through it. Say, okay, we think we've got what we need now, but we need some time. How about let's reschedule a follow-up, if necessary, 2 more weeks from now? And the lawyer says, oh, can't do it in 2 weeks. I can do it in 5 weeks. I'm really busy over the next 5 weeks, so let's do the follow-up 5 weeks from now.
And folks, when a lawyer says I'm really busy, it might mean he's going skiing. But it is very likely that he or she has a trial schedule or a motion schedule in another case, and he or she does not have unilateral power. Far from it. It may have been that schedule itself may have been negotiated by 3, 4, 5, 15 different other parties.
Right. So then let's say you get both interviews done. And then at the end of it, the individual didn't give you information or gave you information you think is not completely accurate because of other stuff you know, or refused to answer some questions. And you say, you know what, we're going to have to put you before the grand jury. We want to lock you in. We want you under oath. And so here's your grand jury subpoena. And then the lawyer runs to the district judge and files a motion to quash. Okay, now you got the motion to quash, and the government has to respond. Maybe that takes 2 or 3 weeks. You file the opposition to the motion to quash. The other side gets a reply. You have to set it for hearing. Oh, I can't be at a hearing on that date. My daughter's wedding is in Geneva that week, and so I'm going to be gone. We need to do it late. Before you know it, 6 months has elapsed going through all of this stuff, and you still haven't got the witness before the grand jury. So that's why you can't just say, why did it take 10 months? There's lots of reasons it took 10 months, or it might have taken 10 months. You've been down this road. I've been down this road more times than I can count. It just does. And oh, by the way, I got 34 other cases I'm trying to manage at the same time.
And mandatory CLE.
Yeah.
We could go on all day, but not today. Ship, thank you so much for culminating. And I'm looking forward to more of your adventures and more of your quality social media postings.
Hey, bring me on here anytime. And as a hint, I might have to have you come on my podcast soon.
Your podcast? Tell us more.
It's just a seed of a kernel of an idea. But
well,
what the hell?
You couldn't get a better guest out of Newark for your first episode. See you later, buddy. Talk to you soon.
Ron,
Thank you.
Take care.